sorry, did I take it? I don't know who was first, second, or third, so you guys care?
Doesn't matter.
Does everybody care? All right. Now, Robert, before you start, if you remember the last time, I mentioned to you that we're going to be reporting back to you on a couple of items that I just thought we needed to report back on. So I hope John Ellsworth. I asked John, and I think I took up a lot of his work, to once and for all get to the bottom of some of the questions that you've been raising relative to the topics that I've asked John to research. So,
would you like me to sit down?
Yeah, you know what, you can sit like the first row.
I'm sorry, but this has been a very long meeting, and I'm kind of pressed for time. And I was going to say that in lieu of how late the meeting was going, I was going to suggest that there's a few topics that we, like you said, you were going to get back to me on, and I'd like to table it to the next meeting. I just want to make this statement. I'm going to move on. Okay.
I think though,
I'm sorry, I don't mean to be argumentative with you. I came up here and I waited all night to speak, to make a statement. I just want to make it. And then everything else that we spoke about, if it's okay with you, I'll let the other people speak. We'll table it for the next meeting.
No, I don't know that we can do that, Robert. You've asked the questions. I told you I'd report back tonight. This gentleman spent the whole week time to get answers. I didn't say you didn't, and I would appreciate if you didn't interrupt me.
Sorry, go ahead.
Okay. So, John, you're
well, I'll sit down, and when he's ready, you can go.
Thank you.
The focus here are posts by Mr. Robert Ripp, which we believe are in violation of item number 3.10 in Facebook's Statement of Rights and Responsibilities. Which directs users that, quote, you will not use Facebook to do anything unlawful, misleading, malicious, or discriminatory. Emphasis added, specifically pertaining to 3 topics which have been the subject of his recent attention: the farm at Oyster Bay, John Burns Park, and the Syosset Park application. We'll start with the farm at Oyster Bay, the Lit Tower estate. Relevant pages on this topic from Mr. Ripp's Facebook posts are contained in Exhibit B. The following are some statements made by Mr. Ripp, directly by Mr. Ripp, not by anybody else who jumped on his Facebook page, on the topic of the federal grant relating to the farm at Oyster Bay. And these are
brief statement to read you, and then I'll reply to Mr. Ellsworth's comments. I'd like to say now that I have never knowingly participated in any criminal activity in relation to my endeavors in exposing misconduct and corruption within Town of Oyster Bay. I can assure you that if I ever learned of any possible crimes being committed, it would be my duty to report any such suspected crime. Recently, I was informed that a town employee from the IT division had been formally charged by the town with listening in on phone conversations on the town's new phone system. I understand this employee was instructed by his immediate supervisor, Eric Tuman, to purchase a specific phone system that begins recording conversations whenever a specific code phrase is mentioned. I understand this phone system covers all the town's phones. I understand this phone system was specifically implemented to address information leaks with the town in the beginning of February 2016. I understand that it was this employee's responsibility, as per his immediate supervisor, Eric Tuman's directions, to purchase, install, and operate this phone system, including programming of the key phrases. I understand that Robert Ripp and Lit Tower were key phrases that Mr. Tuman instructed the employee to program into the system. There is a very strong possibility that this town employee is guilty of a crime if in fact this phone system exists and works the way it was described to me. I don't believe this town employee is the only person implicated in this apparently illegal wiretapping action perpetrated by the Town of Oyster Bay. I strongly suggest that the town supervisor and board immediately contact the appropriate authorities to report this possible criminal action. I originally had no intention of bringing this subject to light. However, I realized that by not coming forward, I could have been perceived as attempting to assist in covering up a possible felony crime. I am no longer concerned about that. I'd like to ask you, does such a phone system exist in the town, and is this information that I've heard true? Would you like to answer, sir?
You know, the only answer I can give you now is to tell you that, I guess it was a few weeks ago, the entire matter was handed over to the Nassau County District Attorney's Office, and we'll await their findings to see who has that fact right.
Okay, good. Just moving on to Mr. Ellsworth. I hope I said his name right. I would assume that, first of all, what's my opinion is my opinion, and I suggest that you contact Facebook and ask them to remove that stuff, and if they agree with you, they will. If you feel that Nelson and Pope has a criminal action against me or a civil action, please begin. I'm not going to dispute everything that you said. I'm not going to waste everybody's time, but just because you say something is fact doesn't make it fact, and I'm going to give you one example. This is a report that was prepared by Nelson and Pope in relief to John Burns on November 4th, 2008. And on page 2, this report is signed by Stephen L. McGinn. On page 2, excuse me for 1 second, I'm sorry. Now on page 2, there's a paragraph that's called Groundwater Contamination Evaluation and Remediation. What it reads is, following excavation of contaminated soils, exposed groundwater will be inspected for the presence of free-phase floating product. Should any floating product be observed, then removal will be required. Initially, floating product will be skimmed from the water surface using a vacuum truck until it has been removed to the greatest extent practicable. The excavated area will then be inspected approximately every 2 days, and product skimming will proceed until no more floating product can be practically removed and or discontinuation has been approved by the DEC. Now, what I'd like to bring to your attention is, on November 24, 2008, Clearflow came in and removed 4,000 gallons of what was eventually disposed of as stormwater and groundwater, non-potable, non-RCRA reportable contaminated material. So, for you to stand up here and tell me that the excavation was pumped out, oh, by the way, excuse me, that was on November 24th. 2 days later, the town started, or Nelson and Pope, whoever was doing it, started pumping the rest of the accumulated water or whatever it was into the sewage system. Okay, so I'm sorry, sir, but for you to stand up here and tell me that the removal of that water by Clearflow was done in the manner that you did, your instructions specifically say that they were supposed to skim the water because the oil and the contaminant fluids raised to the top, they were supposed to periodically skim it every 2 days. That's not what happened at all. And as Mr. Vendetto said, when you tell one lie, everything that you say after that can just be discontinued. The only other subject I'd like to speak to tonight, because, quite frankly, it doesn't matter what Mr. Ellsworth says up here, because what he says is not fact. Right? If his company decides to sue me for any reason, or if the town decides to take legal action against me, then he could provide his whole explanation in documents to the court, and then we could determine who's right and who's wrong about everything. Just because you prepare a report and you stand up here and you read it, don't make it right. What I'd like to talk about now is the indemnification process in the town. I touched on this briefly with you in the last meeting, and I'm talking about the authorization. We don't know how much money you've authorized in total for outside counsel because you refused to tell anybody. What I have in front of me is a resolution. It's number 111-2006. The meeting February 23rd, 2016, it just happened. You just approved, upon the recommendation of Leonard Genova, Town Attorney, Thomas Bellicle, Special Counsel, the law firm of Clayman and Rosenberg, gives their address, was authorized to represent a number of town employees whose identities were discussed in executive session in recent proceedings, and be it further resolved that the town board finds a waiver of the procurement policy to be proper due to the sensitive nature of proceedings and the unique skills required in handling the proceedings. I would like to point out, excuse me, a little sore throat. What I'd like to point out is the town, like I mentioned in the last meeting, you specifically have Chapter 22, Defense and Indemnification of Officers and Employees, okay? And I'd like to just first touch on Chapter 22-8, conditions for defense or indemnification. Now we're talking about a number of employees, and first of all, let's be clear. We're only talking about civil litigation, right? Employees aren't entitled to be indemnified in criminal actions, right? Is that correct? Are we clear about that?
We've already discussed this, I believe, and I really don't have anything further to say about it.
Okay, great. All right, so the conditions for defense or indemnification. It is the duty to defend or indemnify and save harmless prescribed by this chapter. I'm sorry, hold on a second. Let me show you a second. Okay, it's the duty to defend and indemnify and save harmless prescribed by this chapter shall be conditioned upon, shall be conditioned upon the delivery to the town attorney by the employee of the original or a copy of any summons, complaint, process, notice, demand, or pleading within 10 days after he was served with such document. All right, so first of all, for anybody to even be indemnified, they have to be sued first, number one. Okay, there is no, we might get sued, so we're going to hire we're going to hire attorneys. You have no procedure to follow that. All right. I'd like to draw your attention to section 22-3. This is representation by town attorney. All right. It says, subject to the conditions set forth in this chapter, the employee shall be entitled to be represented by the town attorney, provided, however, that the employee shall be entitled to be shall be entitled to representation by private counsel of his choice in any civil judicial proceeding whenever the town board determines upon the recommendation of the town attorney, pursuant to his investigation, review of the facts and circumstances of the case, that representation by the town attorney would be inappropriate, or whenever a court of competent jurisdiction upon appropriate motion or by special proceeding determines that a conflict of interest and that the employee is determines that a conflict of interest exists and that the employee is entitled to be represented by private counsel of his choice. And it goes on to read, this is very specific rules that the town is supposed to be following, your own rules. The town attorney shall notify the employee in writing of such determination that the employee is entitled to be represented by private counsel. The town board, upon recommendation of the town attorney, may require as a condition to payment of the fees and expenses of such representation that appropriate groups of such employees be represented by the same counsel. If the town board determines that the employee or group of persons is entitled to representation by private attorney fees and if the town board determines that the employee or group of employees is entitled to representation by private counsel under the provisions of this chapter, the town clerk shall so notify the comptroller. Reasonable attorney's fees and litigation expenses shall be paid by the town to such private counsel from time to time during the dependency of the civil action or proceeding, subject to certification that the employee is entitled to representation under the terms and conditions of this chapter by the head of the department, commission, division, office, or agency in which such employee is employed, upon approval of the town attorney and upon audit of the control of the comptroller. Okay? Any dispute with respect to representation of multiple employees by civil counsel or the amount of litigation expenses or the reasonableness of attorney's fees shall be resolved by the court upon motion or by way of a special proceeding. All right? I'd like to draw the town's attention to Chapter 22-4, determination of entitlement to defense.
Well, while you're taking a break, I just wanted to address what you had said about John Ellsworth's comments. I'm not sure what you meant by he intends to bring litigation against you or his company intends to bring litigation against you. I think, and I certainly don't mean to put words in John's mouth, that he's referring to Facebook's policy, which states that before we can, as a municipality, request that they remove something we have up, that we have to first request it from you. and that material that we are entitled to request be removed fall into one of two categories, either things that are misleading, or, and I don't know the exact language that John used, but it was things that are basically intimidating, threatening, bullying type language. So, I was thinking about that, and there are a lot of statements that you've made on your Facebook page also that I think fall under that category. And I'm not necessarily comfortable using some of the language that you've used. You don't have to sit down, I was just going to ask you.
Well, if you want to interrupt what I'm saying to talk about something else, I'll sit down and let you say what you want to say.
Well, I was wondering if you might like to read some of your Facebook posts for us.
No, I'd like to talk about this. And actually, I don't know what you're talking about, but if you have a problem with my Facebook page, complain to Facebook. Complaining to me is falling on deaf ears. And by the way, I just want to point out that the photograph that I posted of you, and evidently it was your husband and your son, let's just make this clear. You put that photograph on the internet to promote your travel business website. I didn't steal that photograph off of you. Hold on. I didn't steal that photograph of you any more than I stole the photographs of Tom Sabelico hugging Rusty Torres. Okay? When you put something on the internet, okay, you have to be very careful, because when it's out there, it's public domain. Anybody can use it for whatever they want. I personally, I had actually removed your photo even before we spoke last week. So I'm not interested in what you have to say about Facebook. You can contact Facebook. Now, what I like to talk about, this is more important. This is what we're spending millions of dollars on here. Okay, determination. Not my Facebook page. Determination. And by the way, anybody can go to my Facebook page. I suggest that you all go to my page and read everything on it. I suggest you go there. Listen, I don't have to answer to you. Okay, I'm here to talk about the determination of entitlement to defense. Where the employee delivers process and a request for a defense to the town attorney as required by 22.8 of this chapter. So once again, the people that are being sued are supposed to come to you and give you the stuff, right? Okay, so when they bring that to you, the town attorney shall take the necessary steps, including, if appropriate, the temporary retention of private counsel on behalf of the employee to avoid entry of a default judgment pending resolution by the town board. The town attorney shall then undertake an inquiry and review the facts and circumstances of the case and forward its findings and recommendations to the town board. The town attorney shall forward therewith estimates as to what the cost would be if the defense of the case were undertaken by a retention of private counsel. The town board shall then determine whether the employee is entitled to a defense by the town. That's, first of all, you have to decide whether they should even be indemnified based on what they did. That's correct, right? Okay, I'm just reading your code. I'll read it again. Mr. McInerney, and then maybe you can tell me if you think it's correct or not. All right. If the town board determines that the employee is so entitled to a defense, then the town board shall make a determination regarding any questions as to the retention of private counsel pursuant to chapter. Excuse me. Let me step back 1 second. The town board shall determine whether the employee is entitled to a defense by the town pursuant to chapter 22-2. So, in my interpretation, if you don't agree, it's okay. We don't have to agree on anything. We don't have to agree on anything. But my interpretation of that means that the town board has to decide whether the people that are being sued are entitled to be indemnified, entitled to the defense. Which would mean that all of you should know everything that's going on with the possible litigation against the town by whoever, because you refuse to release any information. Sorry, hold on. Just moving on to the indemnification procedures themselves. The town shall indemnify and save harmless its employees in the amount of any judgment obtained against such employees in any state or federal court, or in the amount of any settlement of a claim, provided that the act or omission from which such judgment or settlement arose occurred while the employee was exercising or performing in good faith purporting to exercise or perform his powers and duties within the scope of his public employment. The duty to indemnify and save harmless prescribed by this section shall not arise where the injury or damage resulted from ultra-vires acts or recklessness on the part of the employee. So before you indemnify anybody, we have to make sure that it's not their fault that they're in the condition that they're in, correct? And then the last thing I'd just like to bring to your attention, because in my personal opinion, the weight of hiring these outside counsel is on the town board. All right, nobody there should just be a rubber stamp. okay, everybody should know exactly what's going on. I hope that you do, and everybody should agree that we're indemnifying these people. We're spending the town money, but we're not, or in any part of any court of competent jurisdiction, such holding of unconstitutionally or invalidity shall in no way affect or impair any other provision of this chapter or the application of any such provision to any person or circumstance. So once again, I just wanted to bring this to your attention. You're spending, we don't know how much money that you're spending. It's been rumored to be over $1 million for outside counsel. There is no action against the town. Nobody's being sued. I don't believe you have the authority to do it. I believe that you acted against your codes doing it, and I believe that now I brought it to your attention. I think that maybe each of you should start acting as individuals and do the right thing. And thank you very much.
Okay, Robert, thank you. Bob Fryer.